All right, we're now moving on to Note 6, which is a brief summary of other types of business organizations, some of the less used things, and some of the types of organizations that are used by small businesses. Now, one of the constant conflicts in business organizations and how people look at them and how the government and the legislature treats them for the last couple of hundred years has been the reality that business organizations, and particularly corporations, are very important because they serve the purpose of allowing people to invest capital to create businesses without putting their assets, their non-business assets, at risk. One of the major important things about corporation law is that if a corporation has a loss, if a corporation can't pay its bills, if a corporation is sued, the shareholders, the owners of the corporation, are not liable for that. So it becomes an important incentive to get people to invest in your business, knowing that, well, if they decide to put in $1,000, the most they could ever lose is the $1,000 they put in. If that the business goes bankrupt, or if there are unpaid debts or unpaid tort judgments and claims, they will not be required as individuals to be forced to pay those things. Sole proprietorships, general traditional partnerships do not give that protection. However, the benefits to sole proprietorships and general partnerships are that they're very easy to set up. They cost nothing, they require nothing, there's no filing with the state. You do not need your lawyer and your accountant to be involved to get things up and running. You are taxed as an individual, so there's no double taxation. In a sole proprietorship, you do not even have to do a separate tax return. And a partnership, you do have to do a partnership tax return now, but you're still taxed as an individual. So there are reasons why small business people don't want to follow the traditional business corporate structure. It's expensive, it's more complicated, it sometimes could result in their being doubly taxed. However, they desperately wanted and need the protection from liability to keep their non-business assets safe from the claims of their business creditors and business judgment holders. So, realizing this was an issue, the various state legislatures, beginning about 40 years ago with the more business-orientated states, began to look for ways to kind of rectify the situation and basically create a corporate structure that would be available to anyone and everyone, and that could be set up easily and cheaply and did not have to require the input of your accountant and your attorney to maintain it. And what resulted was the creation of something called a limited liability company or a limited liability corporation. Many of you probably have seen at the end of different business names on people's business cards or in their internet ads that their name is followed by the letters LLC, and that is just an abbreviation, a shorthand for a limited liability company. In Rhode Island, the Rhode Island General Laws, Title 17, Chapter 16, is the Rhode Island Limited Liability Company Act. And in Massachusetts, it's Title 22, Chapter 156, is the Massachusetts Limited Liability Company Act. Limited liabilities have some of the characteristics of corporations. You must still file articles of organization with the state, so it is a state created and controlled entity. You must file annual reports with the state to let them know what's going on and that you're still there and still active. But you do not have to set up a set of bylaws. You don't need officers, you don't need a board of directors, and you don't have shareholders. So with a limited liability corporation, you file articles of organization. Those are the basic documents with the Secretary of State, and you draw up an operating agreement. Now, we haven't got there yet, so kind of putting the horse before the cart here, but the owners of a business corporation are the business's shareholders. And they get to vote, and they vote for a board, and they possibly vote for officers who run the corporation, but the owners are the shareholders. In a limited liability company, you do not have shareholders. The owners are called members, and there is no board, and very often there are no officers. And what happens is, instead, in place of bylaws, in place of elections and annual meetings, at the very beginning, as you set this up, you draft something called an operating agreement. And the operating agreement has provisions for the management, who's going to control, who's going to be in charge. It states who the members are, and the members are the owners of the organization. Their ownership rights can be equal, or they can be unequal percentages. And very often they are unequal, depending on how much money or how much time or effort one member is putting in versus another. The filing with the Secretary of State of your articles of organization allows you to make a determination. You can state on the document that you're going to be managed by the members, so the owners themselves will be the managers and they will be involved in making contracts and dealing with the public, or you can appoint managers, and the managers can be the members themselves, but they can also be hired agents or hired employees. So you can have managers who are named. They are not necessarily the owners of the corporation. And it's a very interesting thing here because, in a sense, it allows the owners of an LLC to remain private, to remain silent, because their names do not have to appear publicly on any document. They can nominate a manager, name that manager in their public filings, and that is who the world would deal with. That is who the world would go to in terms of trying to do business with the LLC, and the owners can remain behind the scenes and not be visible. One of the other things that you're allowed to do when you file your articles of organization is to determine your tax status. And you can determine that the LLC be a pass-through, so there's no double taxation. If it's a single member LLC, you can even determine that it have no status separate from its member. So basically, you're filing one tax return again. You're not filing a corporate tax return. And on the beneficial side, the members of an LLC have nearly identical protection from liability that the shareholders of a corporation would have. So it's a very important development. It has become very popular in the last 20 or 30 years that many different types of businesses are moving to the LLC format. And again, with a corporation, traditional corporate structure requires periodic board meetings. They require periodic meetings of shareholders. They require all types of notices be given and copies of the same to be kept and preserved in the corporate records. Notices to shareholders, notices to third parties dealing with the corporation. Can be very cumbersome even for a small corporation, and actually very many small corporations fail to do it. And then when they get sued or when they get into trouble, they have a very difficult time because it looks like possibly they're actually a sole proprietorship that just filed corporation papers, and they run the risk that a court will declare an estoppel and say that, no, we're not going to let you say that you had corporate protection from liability because you didn't behave like a corporation. With an LLC, those problems are limited. You file your once-a-year annual filing. You're not required to have meetings at any periodic time. You don't have shareholders to answer to. The members only have to give notice to themselves for any changes or anything that they want to do. So it's a much simpler operating system, particularly for those small business people who are not going to come back to their lawyer every single year to make sure the papers are filed correctly and the minutes of the meeting are done correctly. Having said that, there are some downsides to LLCs. In Rhode Island, there is a minimum annual tax for every LLC. In Massachusetts, there is a rather high filing fee for the annual report for each LLC. One of the things that happened is that once these became so popular and took off in the 1990s and even the late 80s, the state saw them as cash cows and began to throw fees on them that made them, in some cases, even more expensive on an annual basis than filing for a big corporation. So we've seen a little bit of a slowdown in people seeking to file LLCs, but it's still a very important way to give yourself the liability protection of a large corporation without having to go through all the hoops that a large corporation has to go through. Now, some other entities that are rare, but they're still there. So we will talk about them a bit before we move on to actually looking at corporate structures and the creation and running of corporations. There is something called a joint venture. A joint venture is when two or more persons or two or more entities come together for a specific project. Say, we're going to buy a house, rehab it, and flip it. The participants are considered to be similar to partners. And you have to be very careful here because they can be held liable for the torts and the contracts of each other. Implied and apparent authority exists, although it's not as extensive as you would find with a partnership because the joint venture is only for a specific project. So the only implied authority or apparent authority would exist for that project. When these types of things are set up between businesses, large businesses, then certainly the lawyers and the accountants are involved and formal contracts are drawn up and everybody's rights and duties and obligations are explained and stated clearly. What happens sometimes at this point is two or more individuals or two companies will come together for a project, have no written agreement, have no particular statement that they're a partnership, joint venture, whatever, and then somebody gets injured or somebody who falls down and now claims we're an employee and we need workers' comp, or some bill doesn't get paid and somebody's looking for payment. And again, if the person who is seeking money, seeking a remedy in court, can show that these people are acting together, they could say that this was a joint venture, so therefore they are each liable for everything, or they're all liable for everything. A little bit easier to prove this because you only have to prove information about how they were dealing on this one specific project, where particularly if it's two companies that come together to do a specific project, it'd be hard to show that they were a general partnership because they're not generally responsible for each other's corporate activities apart from this one thing. So there are situations where courts have created judicially during trials joint ventures saying that that's how you are operating, so that's what we're going to call you, and now liability has extended to everybody involved. A syndicate is similar to a joint venture, but it is even more specific. A syndicate is a group of individuals or a group of entities that are willing to put money in to finance a particular project. So they're not going to run the project, they're not going to be in charge of the project, they're going to not be ultimately liable for the project, but they will play the bank. They will act as private bankers here, and they will fund the money. They'll put a pool of money together, and they will fund the money for whatever this project is that's going on by a third party. These are often created by large corporations, insurance companies, banks, stock brokerage companies, as a way to do some creative investing. And needless to say, if those companies are involved, then you have a whole stable of lawyers and a tribe of accountants, people representing everybody. There would be a written contract, and the rights and the liability provisions of who was responsible for what will be all spelled out in those agreements. Sometimes this does not really exist today, and certainly there are no new ones being created, but you might in some of the old cases come up with this term, a joint stock company. In England, going back a couple of hundred years ago, you could set up a company without necessarily getting a charter from the government, and without necessarily filing. You just would open up a business and you would start selling shares to your friends or your neighbors or whoever, to anyone who wanted to invest. By law in the United States, this is not possible at this point. If you are going to be selling shares in a corporation, in some business venture, it is highly regulated, particularly if you're selling the shares to the public. And because of that, you actually have to meet the tax laws, to meet the Securities and Exchange Commission regulations and laws, you'd have to have formal business corporation structure. But again, some of these things existed extensively in England. I've read some of them survived even up into recent times. There may still be some that exist and have like grandfathered rights, and you will from time to time see this term come up in the old cases. So just be aware. Same thing with business trusts. Now, a trust is a peculiar thing. A trust is an entity, an artificial entity that we create by way of drafting documents, usually called a trust agreement. And what it is it creates a vehicle to hold the title to property and to place certain conditions and restrictions on how that property will be handled. The structure for doing that, the mechanism for doing that is you draw up a trust agreement. You'd have to go to your attorney and draw that up. Whoever is putting property or assets into this trust is called the set law. They're setting up the trust. And what they do is the trust actually divides legal and equitable title into two different sets of people. The trust will have a named trustee, and the trustee will hold legal title to the property. So if it's to be bought or sold, if you're going to borrow money against it, if somebody gets injured and is going to be sued, they would sue the trustee of the trust because they are the legal owner of the property. However, the trustee stands as a fiduciary, and his obligation or her obligation is to handle this property for the benefit of named people called beneficiaries. And the trustee has a high duty of care in making sure that the beneficiaries' interests are protected and watched. Beneficiaries cannot be sued directly because they don't manage, they don't run, they're not involved. The trustee can be sued, but could only be sued up to the extent of the assets in the trust. These were used by businesses in the past to come together and do certain things. It's rarer and rarer to see that happen. Mostly today we see the corporate structure, either in a regular business structure, in an LLC, or in a limited partnership being used. But there still are some business trusts out there. Massachusetts has a peculiar institution called a Massachusetts Nominee Trust. This trust in the past was used extensively to hold title to commercial real estate in Massachusetts. And what happens in this trust is that somebody places a piece of real estate into the trust, they name the trustee, and by law, the trustee is forbidden from revealing who the beneficiaries of the trust are. And therefore, the beneficiaries can never be sued, and the trustee is the person in charge of running this real estate. Owners of real estate that they rent or lease out to other people are in a very difficult legal bind, in the sense that they are letting their property be used by other people who may or may not be careful, who may or may not cause damage, who may or may not burn the building down, who may or may not do things that injure other tenants or other visitors to the buildings. And yet, when these things happen, because the owners own it, they are going to get dragged into the lawsuit. And even if they ultimately win, the cost and expense of defending themselves can be outrageous at times. Massachusetts, for a very long time, made it very difficult for small-time individuals to create corporations. Massachusetts was very late in time in making corporations a ministerial act where you just go to the Secretary of State, file some papers, and boom, you have a corporation. Traditionally, you had to have a bill passed in the state legislature to create your corporation, and Massachusetts held on to that for a long time, and even when they changed, they still made it difficult to create a corporation. So in order to get some protection from creditors, some smart lawyers came up with the idea of this type of trust. And so basically, the set law does not have to be named, and the beneficiaries can't be named. They're not allowed to be named in court. You cannot seek discovery to find out who they are. And it became a way of investing in real estate and protecting yourself, because if you had one trust set up for each piece of real estate, somebody got hurt, they sued the trustee holding that real estate, they can only sue that trustee for the activities concerning the real estate in that trust. So in effect, you have protected part of your assets or your other assets, and the only thing that somebody could go after would be the assets in the particular trust that they were filing the lawsuit against. With the advent of limited liability corporations, the Massachusetts nominee trusts have begun to diminish greatly lately. Lenders, particularly since we have now gone to a situation where most of the lending in the country is done by national banks that don't have particular connections to any state, they're not too happy with Massachusetts nominee trusts. They make it very difficult to obtain mortgages or loans for these properties. So they have been dropping off, but there still are thousands of properties in Massachusetts that were put into nominee trusts a number of years ago, and they still hold title to the property, and they still chug along. This type of trust is not recognized under Rhode Island law. Our courts have never acknowledged this, and the title insurance companies who make the transactions happen in real estate refuse to honor them in Rhode Island. And if you try to put property into a nominee trust in Rhode Island, and a title company attorney is watching the transaction when you go to refinance or sell, you're probably going to be in Superior Court reforming the title to the property, because the Rhode Island title companies, at least to my knowledge, the last time I dealt with this, universally held that nominee trusts are not valid in Rhode Island, that a trustee cannot convey property without revealing who the beneficiaries are. And some of our tax provisions for the transfer of real estate and paying of capital gains taxes in Rhode Island would also mitigate against this type of trust, because they specifically say that any monies going to beneficiaries from a sale of a Rhode Island property are subject to capital gains in the hands of that beneficiary, and the state demands to know who they are, what their social security numbers are as part of a real estate transaction. So by definition, a nominee trust would at present be in violation of our tax laws in Rhode Island. A cooperative is another type of association that is much more common out in the Midwest. Many farmers and different type of agricultural businesses are formed as cooperatives. What a cooperative is basically, it's an association of people involved in a certain business looking for a certain service to be provided, and they get together and they set up this business, and all the people who participate in utilizing it are members of the cooperative. They are the owners. The closest thing we have in Rhode Island to this, and it's not exactly similar because it falls into banking and the banking rules also, but operating in almost the same way are credit unions in Rhode Island and Massachusetts. The way credit unions are structured is that by opening up an account, and usually it's for a very low amount, $5, $10, $25, you open up an account at a credit union and you become a member of the credit union, which means you are in effect an owner of the credit union. Every January you can go to their board meeting where they elect their board and their officers, and you get to vote. You can solicit, you can demand the names of other members so that you can go out and try and put together groups, blocks of voters if you want change. And basically, you own this business that you now utilize for your banking services. Out in the Midwest, cooperatives were set up very often by farmers who needed grain silos to store their grain, or needed milling facilities to mill their grain and package it and get it ready for shipment. And that was a thing that was too expensive for an individual farmer to do, but yet they didn't want to turn it over to some of the big corporations, so they would set up small cooperatives with a number of farmers in it. Recently for me, in the last 20 years or so, a number of small alternative supermarkets and grocery stores and other types of things have been set up as cooperatives. But difficult to maintain, difficult to make money in them. Usually they're not there to make money, but they're there to make sure that there's some structure for this group of people to be owners and to participate in some service that they need. And not very common in Rhode Island or Massachusetts at all at this point. Okay, to wrap up this section 6, just a few considerations. For businesses, limiting liability is one of the most important realities. It's probably second important to making money and making a profit. However, it can be handled by insurance. And very often when my clients come to me and they're talking about setting up an LLC, and I'm listening to them and I'm knowing they're not the type of people that are going to follow through on this. They're not going to follow the rules. They're going to be totally befuddled when tax time comes as to what to do about filing their taxes and how to claim different things and whatever. I very often will say to them that rather than do this, make sure you have sufficient insurance. Make sure you are well insured, particularly for liabilities. One of the other realities, too, with setting up these small corporations is that you cannot escape your own negligence. So if you are a sole proprietor and you set up a corporation, for your business, but you are the one who does something negligently, you're going to be sued individually. And then your corporation is going to be sued under the idea of vicarious liability. So for some very small businesses owned by one person or by a couple or several family members, they're not really getting out of liability problems by setting up a corporation. And what is a much better use of their time and money, I think, is to make sure that you are very well insured. And then when something happens, you turn it over to the insurance company and their lawyers. And you pay whatever deductible it is you decided to pay, $500, $1,000, $5,000. And once you've paid that, the rest of it's up to the insurance company. And if you have $1 million or a couple of $1 million worth of liability insurance, there are very few things in this part of the world that $1 million will not make go away. So in recent years, at first, there was a big push for everybody to set up limited liability corporations for everything. And then we began to see some of the downsides of it, the taxes that have to be paid in Rhode Island every year, the filing fees that have to be done. And a number of my clients now are holding assets in their own names again, but just making sure that they have the adequate and important insurance coverage if something should happen. The one thing that corporations do give is continuity. A corporation can exist theoretically forever. So when it comes to issues of the death of the owner, the illness of an owner, it is a little bit easier to deal with a corporate structure than an individual with no structure whatsoever. Having said that, reminded me of something that in limited liability corporations, a member can sell their interests. So we set this up. We don't have shareholders, we have members. Each member owns a certain percentage interest of the business. A member can choose to sell that. However, if they sell it to a third party without permission of the other member or members, that third party does not get automatic rights of control or management or voting rights in the organization. So their interest can be sold, it can be transferred, it can be inherited. But there has to be some acquiescence or agreement on the part of the other members to go along with that. Last thing I want to talk about here is a little bit, and we'll get into this more, I think, when we get into corporations, we'll go over this a little bit more, but there are different ways to obtain money. And one of the big issues in business is finding the money to get going, to keep going, to deal with the ups and downs of production. I mean, if you think of a farmer, they have to spend tens of thousands, hundreds of thousands of dollars on equipment, on seed, on fertilizer, on preparing the land, on labor, and they only get paid once a year when they bring in the harvest. So they have a point when a large sum of money comes in, but then they have other points when there's no money coming in at all. And many people use loans to cover those periods when there's no money coming in. I mean, the same thing happens with businesses, particularly if you think of a seasonal business, a landscaping company, restaurants that are down in the beach areas. They're going to have extremely busy, high times when they make lots of money. They're going to have times when they make little money. The other reality is if you're trying to open up some type of business, if you're trying to open up a restaurant, the amount of equipment that's involved, the number of people that you have to hire and pay, the licensing that you have to go through, and all of this before you earn a penny of money, before you have a penny of income coming in. So very often, one of the biggest issues in business is how do we finance this? Can we borrow money or can we put together money to make this idea happen, to begin to do this thing that we want to do? And of course, there are several ways of doing that. First is traditional loans. You borrow money either from a bank or you borrow money from a third party. One of the difficulties with that, of course, if you're borrowing money from a bank, you have to qualify, you have to pay interest. If you borrow money from a private party, sometimes the qualifications are easier, but the interest rates are usually higher. Right? There is something called venture capital. Venture capital is the idea that you seek investors in exchange for ownership rights. So this wouldn't happen so much with a limited liability corporation, although it could. It could be structured in such a way that one member would contribute money and the other member would contribute their ideas and their labor. And I have had a couple of situations with clients where that has happened. But usually we talk about venture capital in the regular corporate situation where there's somebody with an idea. They know they can do something, they believe they can make money, but they have no money to get started. And there are people who have money, who are looking to invest it, who are looking to find another Microsoft, another Apple, another Google, another Facebook, to put their money in at the beginning and to hopefully have that money expand multiple times by the company becoming successful. Um, that is really the definition of capitalism, which, contrary to everything that seems to be going on in public right now and in the political sphere, capitalism is still one of the bases, although it's been highly changed and maneuvered and kind of mutilated into something nearly unrecognizable. But the basic idea of capitalism, going back to the British investors of the 16 and 1700s, is that you're a business person, you work hard, you pay your bills, your business is going, you have your house, you have your ability to live, to eat, to buy clothes, to do what you need to do, and you have some money put away. Well, you can put that money in a bank and you can make 1% interest on it. Doesn't seem like you're going to get very far in your life with that 1% interest. And if you're living in a time when there is inflation, which means the cost of goods and services is rising, the interest that you get paid by a traditional lending institution isn't even going to keep up with the money, the value that you're losing by way of inflation, by being able to buy less goods and services with your money. So what the English made a science of was coming up with a way to allow people to take some of their savings, their capital, and to give that to someone else, some bright young person who has a good idea, who might make millions or billions of dollars, and have an agreement set up where if that happened, my capital would have a guaranteed return on money, and I would make far more money than any bank or other lender would pay me for just putting it in an account. And that's really the whole basis of our system as it began and as it came to the 13 colonies under the English. So venture capital is still alive today, although the COVID-19 virus has kind of put a crimp in it at the moment, but it is still a very important thing. It was a very big factor in the development of personal computers and the whole tech revolution that has gone on during my lifetime, that has allowed you folks to have all the wonderful things like computers in this video, and Android phones and Apple phones and all the other incredible technology that is now at our fingertips. Venture capital was what was behind that. The old-fashioned, stick-in-the-mud conservative banks wanted nothing to do with investing in what was going on in Bill Gates or Steve Jobs or Steve Wozniak's garage when they were in their 20s. And they had to, at some point, go and seek private people with private money who were willing to take a risk. And in our system, by use of the corporate structure, they were able to mitigate that risk. They were able to contain that risk only to the amount of money that they wanted to put into the project. All their other assets that they worked so hard for over their lifetimes were protected. So very, very important psychological and economic engine for creating growth, for creating new businesses, for allowing new ideas to get funding and to take off. It's been interesting the last few years, although some businesses have, but I'm not too sure that many have done it. But crowdfunding, going online and soliciting money from millions of people, small amounts of money from millions of people, is becoming a more and more prevalent way of getting together base capital. And it's an interesting idea. I think it's going to run smack into a lot of the regulatory issues that big corporations have with the securities laws. But at the moment, it certainly seems to be working for political purposes. It seems to be working for charitable purposes. It's very easy if somebody needs a operation they can't afford, somebody's been injured, and their family's about to lose their house in that. It's amazing to watch how people will donate $5, $10, and all of a sudden that rises up to $1 million to give to the people who are needy and have, subject to illness or some kind of accident or whatever. And I am certain, just as Bernie Sanders, people came along and in both campaigns utilized that to allow them to 10 and 12 and 15 and 20 and $25 at a time to raise an incredible amount of money for the political campaigns. I'm sure that business people are all watching that, and we're going to see more and more businesses trying to take off that way. Okay, that ends note 6. We will be going on shortly to give you lectures on note 7 and 8. Over and out.